Okay, it looks like we are going to get started. First, thank you all to our panelists today for their participation in today's discussion as part of our overarching theme and conversations related to restorative justice in the criminal legal system in our webinar series. So for those tuning in for the first time, welcome. My name is Avery Arrington. I use she and her pronouns, and I'm one of the assistant directors for the National Center on Restorative Justice, where the majority of my role is to help provide general public educational opportunities for folks. The National Center on Restorative Justice is a partnership between Vermont Law and Graduate School, the University of San Diego, the University of Vermont, and the U.S. Office of Justice Programs. Special thanks to our funding partners, the Bureau of Justice Assistance, as we're charged with addressing some of the pressing needs in the criminal justice system. We're committed to improving policy and practice through restorative justice research, public education, and higher education. So in your free time, please run over and visit us at ncorj.org and check out some of the National Center's incentives, some of the research developments, as well as the educational opportunities we offer. And I'd be remiss to not mention that all the resources we offer are free of charge. All right, so without further ado, I'm going to turn it over to today's moderator, Robert Sand.
Thank you so much, Avery. I'm Bobby Sand. I use he, him pronouns. Briefly, I'm a professor at Vermont Law and Graduate School and the founding director of its Center for Justice Reform. I'm an advisor to the National Center. And for 15 years, I was the elected state's attorney, or DA, for Windsor County, Vermont. In thinking about our webinar today, I realized that there are really dual meanings to what we're calling this webinar: restorative justice for prosecutors. So certainly one meaning is, how can prosecutors use restorative justice as a response to harm? And I think that's probably the most obvious meaning. But we could also interpret restorative justice for prosecutors as meaning, how can prosecutors within their own offices use restorative justice as a means of building community and communicating between and among prosecutors? And perhaps during the course of the webinar today, we'll have an opportunity to think about both of those meanings. So we all know prosecutors have an extraordinary amount of power and discretion. Many people say prosecutors are the most powerful actors in the criminal legal system. My hope today is that all of us will think creatively about how we can exercise that power and discretion, and what is the role for restorative justice in the exercise of that discretion. So we have an incredible panel here today, and we literally span the continental US. So I'm going to very briefly introduce the panelists and then give you a little bit more information about the webinar. So from the West Coast, we have Damaris Evans, a senior assistant district attorney in the Alameda County DA's office, California. She's responsible for supervising RJ implementation, Racial Justice Act coordination, and the post-conviction unit. From the Mountain Zone, we have Chris Brown Haugen, and Chris is a deputy DA in Denver, Colorado, and is in charge of the RJ, Restorative Justice, and Diversion program. From Chicago, we have Jay Jackson, an assistant state's attorney in the Cook County, Illinois DA's office. That's the second largest DA's office in the country. And Jay, I'm not sure if you coordinate, but is actively involved in the RJ Community Court. And we'll hear more about that shortly. And then finally, from the East Coast, where I'm from in Vermont, the 802, we have Sarah George. And Sarah is the elected state's attorney for Chittenden County, Vermont, our largest county by population. And it's the location where Burlington, Vermont is. And Sarah is a leader in the state and nationally now in less punitive responses to harm. So panelists, I've shared some questions. I have a very bad habit of freelancing, so forgive me if I do. I'm going to direct some questions to some of you, and please feel free, if I haven't called on you, but you'd like to add something to the responses that have been given, please just unmute and do so. And I'll tell you that our questions are both philosophical and practical. So let me start with perhaps a somewhat philosophical question, and we'll say this, audience folks, the amazing Avery Arrington will be monitoring the Q&A, and when we're done with the panelist presentations, time allowing, we'll get to your questions, so please post them into the Q&A. So my first question, Chris, I'd like to start off with you, is using RJ and using restorative responses to harm compatible with your work in a prosecutor's office?
Thanks, Bobby. I would say absolutely, and I'd go further than compatible to say that it's even essential to the role as a prosecutor. When I think about prosecution, I think about our role in keeping communities safe and seeking justice. And when I think about crime and those who have committed crimes, I think oftentimes that those are people who are harmed, who have not had harm repaired in their lives. And when I think about restorative justice, there is no better way, in my opinion, to repair relationships, to repair communities, to repair ultimately our world, if we want to go completely idealistic, than through restorative justice. I think offering an opportunity to get to the root of crime, to get to people who are hurting and how we can make their lives better and how we can repair relationships so that people aren't living in a life where they're constantly in this state of disrepair. To me, that is one of the best ways to keep communities safe, to ensure that people are able to live productive, healthy lives. And ultimately that goes to some of the broader kind of more traditional goals within our system of reducing recidivism and lowering crime rates. And so, in my opinion, absolutely.
Thanks, Chris. Sarah, compatible or incompatible with your work as a prosecutor?
Absolutely compatible, and I agree with Chris. It's actually quite essential. I think I'd echo everything that she said in the beginning, and then just sort of expand a little bit on that last point that she made, that we can talk a lot about the benefits of restorative justice in the harm that's committed in that particular case, but as public safety officers, our obligation is also to future crime and recidivism, and restorative justice practices have significantly higher, they are significantly better in reducing recidivism rates than our current system. So the word compatible is interesting because it's really opposite of historically what our roles as prosecutors have done, but I think it's compatible in our essential role as prosecutors. If you think about it as harm reduction, public safety is harm reduction, and the current system as it operates is very harmful, and restorative practices and restorative approaches are significantly less so. So it's better for the particular case at hand and the future of your community.
Interesting. So what I think you're both saying is it's not just an option, but it's a fundamental part of your respective roles and a fundamental part of what you two see as being a prosecutor's role. Fair characterizations?
Yes.
All right. Jay or Damaris, do you want to weigh in on this, or, well?
Yeah, I would just echo. I would echo what has been said already.
Great.
Yeah, same.
Okay, so I'd like to give each of you an opportunity to maybe introduce yourself a little bit more than the short intro that I did, but also to explain the RJ program or work that you are doing with and through your office. because one of the things I think we'll see is that RJ takes many different shapes across the country. And if it's all right, let's go west to east. So Damaris, if you would, could you tell us about your RJ work in California?
Sure. And Avery, this might be a good time to put the infograph up about restorative community conferencing in Alameda County. And so, well, hopefully Avery is getting that infograph up. Here we go. This was created by Impact Justice, which is an organization that provided technical assistance to the Alameda County District Attorney's Office, and Community Works West, the organization that handles a lot of the, or pretty much all of the restorative community conferencing here in Alameda County. So it's sort of an infograph that describes the process that happens in a visual form, starting off with, and it started here in Alameda County with minors or juvenile matters in the juvenile court. And so the person who caused harm is referred to as youth throughout here. And it's mainly continues to be focused on juveniles with a pilot that involved transitional age youth, which was 18 to 25-year-olds, but has mainly been focused in the juvenile court. And so starts out with the young person who committed an offense being arrested, and referrals can be made through either the police department that handled the arrest, through the probation department, or through the district attorney's office. And these referrals are all pre-charged before the case is actually charged for the most part. There's been a couple of exceptions where cases have been referred after charging has happened, but the program focuses on pre-charge cases. So any of those entities can refer the case to the community-based organization, which is Community Works West here. And then that is diverting it from going through to court. So you can see the line at the top shows if it went through the traditional system with court and the youth being sentenced and probation, and other sanctions if, you know, the charges are sustained. With the diversion, the individual youth, after the referral to the community-based organization, they meet with the young person, also meet with the person who was harmed or the survivor. Both individuals would agree to participate, and there's pretty extensive preparation that happens before the restorative community conference to make sure that it's a safe space for the person that was harmed, and also to make sure that the young person or the person who caused harm is prepared to accept accountability for that harm. Then the restorative community conference happens. You can see down below that during that time, there's a number of people that are also involved, supporters of the young person, caregivers. It could also be community members. And there's a facilitator who's someone very experienced in holding these conferences and making it a safe space and a space for authenticity for all involved. Now, once that conference happens, during the conference, there are usually agreements where the young person agrees to do a number of things to make the harm right as much as possible. Some examples here are replacing what was broken or lost, enrolling in certain programs. It could be a number of things, and these things are largely driven by the survivor or the person who was harmed. And these things are also designed to address the root causes of the harm. And the community-based organization here, Community Works, actually monitors those agreements. And once those agreements are completed, then the case can be discharged and no charges are filed. And this results in sort of disrupting this cycle of incarceration instead of contributing to further harm, which we have a lot of research now showing that, especially for young people, engagement in the criminal legal system can tend to lead to more harm. And so this will, I'm sure, probably come up later, but since we have the infographic up here, just show that a study of this program here in Alameda County showed that it resulted in 91% satisfaction for participating victims and a 44% reduction in recidivism for the young people who were involved.
If I understood you correctly, are the RJ services provided by a community-based entity?
Yes, the community-based organization provides all of the services, and that is all held in the community and outside of the traditional court system.
Okay, and so I flagged that because I think we'll see some contrast. So California, thank you. Denver, Colorado, Chris, can you tell us about yourself and the program you're involved with?
Sure. So I run a program out of the Denver DA's office. It's a partnership. So it's a partnership between the Denver DA's office and a nonprofit here in Denver called the Conflict Center. So it is also all the programming is community-based in Denver as well, but all the screening and referrals are post-filing, but pre-plea. So no one is taking any kind of a plea. Cases are identified and then they are screened by the DA's office and referred to the community agency. Our program is actually specifically for adults, which is a little bit unusual in the restorative justice landscape, but it's for people who are charged either in county or district court. So there can be there's dual jurisdiction on traffic cases for teenagers or juveniles, but generally it's for adults. We have a pretty broad array in terms of what cases are eligible to be referred. There are very few bars in terms of what would keep a case out. We won't take any domestic violence cases. We won't take a couple of specific gun charges, but other than that, it's really open to any charge. The gatekeeping sort of functions that determine which cases are appropriate is that the victim needs to be open to the case being handled through our restorative justice program. We don't require participation, so we will take a case if a victim is okay with the case going through restorative justice, but does not want to personally participate. We have surrogates who often participate on their behalf. We have a community-based conferencing model as well. And so there are always community members that participate in every case. So if a victim doesn't want to personally participate, there are other ways so that defendant or party that caused harm still has the opportunity to participate. And then the individual district attorney has also the gatekeeping power to determine whether or not they think a case is appropriate. We are limited most sort of by our capacity. The partner that we work with, our community partner, they can handle about 10 cases a month. So that's 120 cases a year, which is better than when we started. We're in year 4 of our program now, but not where we'd like to be. They are all volunteer facilitators who run this program, who run their programs, run the conferences. And so they use two volunteer facilitators for each case. So that's 20 volunteers a month, which is kind of where they're stuck with the capacity issue. So our kind of next issue is how do we scale this so that we can bring more cases into the program. But both felonies and misdemeanors are eligible. I'd say generally we have about 7 to 8 misdemeanors and 2 to 3 felonies a month. The longer the program is around, the more sort of culture change or openness that we're seeing within the DA's office to the program, which has increased both sort of the severity of the cases that certain DAs are willing to refer. But it's also limited because of, again, our capacity. So we're always kind of looking at ways that we can expand it and work on equity, which I know will be a question later. So I'll save my comments on that for that part. But then once a case goes, I screen them, make sure that the person is taking accountability. It gets then referred to the conflict center. They go through again, like Damaris was talking about, a series of preparation meetings, making sure that there won't be any further harm by the time the community conference comes around. The facilitators bring together the party that caused the harm and the party who was harmed if they're participating, support people if they choose to have them, and then 2 community member volunteers. They come up with an agreement as well, focused again on repairing the harm that was caused. And then the party who caused the harm has a period of time to complete that agreement. If they are successful, they notify me, and then I move to dismiss and seal the case. So at this point, we've had about 315 cases referred to the program. About 260 have successfully completed. We run recidivism reports a couple times a year, and our recidivism right now is at 3%. So that's been really exciting. So we're seeing lots of promising results and hoping that we'll be able to just kind of increase funding so that we can increase our referrals.
Is there statutory authority for what you're doing, or was this simply a decision made within the DA's office?
It was a decision made by our elected DA, Beth McCann, that she wanted to offer alternatives. She started a few different alternative programs within our office, and this was kind of one of the things that she wanted to do. We do actually have more statutes on restorative justice in Colorado than I think anywhere in the country. So there are quite a few, but in terms of sort of the onus on the prosecutor's office, the only statute that really applies is just that victims are supposed to be informed that restorative justice is an option in their case. And so this program was really more of Beth's vision of wanting to just start incorporating restorative justice more into the criminal system.
So interesting, just worth noting that an elected DA has the power and discretion to launch an initiative like this. Jay, tell us about your work at the RJ Community Court in Chicago.
Of course. So I'm in the Cook County State's Attorney's Office. I'm part of the Alternative Prosecutions and Sentencing Unit, in which our unit handles all of our specialty and diversion courts. Specifically, we have the Restorative Justice Community Courts that I am assigned to 2 of them. My partner covers the 3rd. The Restorative Justice Community Courts cover 3 target areas in Chicago's southwest and south side, west side, and then northwest side. So that would be Avondale, Inglewood, and North Lawndale. So the way that our intake process works, very similar to my fellow panelists, except we target 18 to 26-year-old nonviolent offenders. And that means either the crime or their background, both need to be nonviolent. And the screening criteria is that they live, work, worship, or have strong ties to those 3 target communities. We can make exceptions based on whatever mitigation we receive, but typically we stick with that. And our process is after arrest, post-charging. Typically what happens is we have some of my colleagues in my unit, we screen cases as they come into our court of first appearance. We have a bond court right now that may be changing. But essentially the morning after everyone gets arrested and they have to appear for court, the police reports that get sent in, we have individuals that sit during bond court every morning and they screen every case that comes in for our diversion courts. So we look for individuals who are 18 to 26-year-old charged with an eligible offense and that lives within the target communities or very close to that area. And then from there, the individual cases are either, they go on to the preliminary courtroom where they have their preliminary hearings. Sometimes the preliminary hearing ASA sends the case, sometimes they don't. Once we flag it, we put an indicator on the file and in our system that they are eligible for restorative justice courts. So whether the case gets sent over from the preliminary hearing room or from the trial room once the case gets indicted, we still have already either screened it prior to that or we'll screen it at that time. And then once the case gets sent to us and the court, the first thing that the participants have to do is, well, after going over all the terms and conditions of our program, they will meet with our social services officer. We have representatives in all 3 of our courts, a member from our social service department. They also handle our adult probation and our pretrial services in our county, but they will do an intake evaluation with those, our social service officer. And then through that, some needs are identified and they're basically screened using the ORIS assessment, the Ohio Risk Assessment, which identifies their level of risk and need. And then from there, they that ORIS evaluation, along with recommendations of their needs, are sent over to our community, our circle keepers for that individual court. And then from there, the participants begin the peace circle process, in which they will meet with 2 circle keepers, the individual who was harmed if there is an identifiable victim. If not, then we have a surrogate victim stand in, and then members of the community who, in coordination with the participant, they will come up with a set of terms as a way to address and repair the harm, while also taking accountability for the offense that was committed. Sorry, the ways that ours, I would say, is different is that we do have, like I said, 3 standalone community courts, and you know, rough numbers. One court has 120 cases currently. One court has 96 cases currently, and one has 53 cases currently. So, and each of these courts, they are based in a community center in that community. So in Avondale, it's based in a church that does a lot of community work, and then in Inglewood, it's in our Salvation Army Center, and then in North Lawndale, it's in our it's in the UCAN facility, which is a community-based organization that provides services. And then yes, so they're assigned a case manager. They come up with their repair of harm agreement. Once that's entered, we just do status check-ins to see the progress they're making, verify they're actually completing the goals, and then once they complete all the terms of their repair of harm agreement, I dismiss the case, and then we set them up with services that helps provide expungement for the arrests.
Yeah, great. Jay, so you've used the term court, but I didn't hear any mention of a judge. Are there judges involved?
Yes. So the way it is set up, we do our best, and I know we're going to get into it later, but we do our best to keep our restorative justice courts separate and identifiably different from the traditional court. So here at 26th Street, where the main courthouse is, you know, there's the judge, the bench, everybody's looking down. I mean, the judge is looking down on everyone, you know, parties sit on the opposite sides. In our restorative justice courts, we all sit in a circle during the hearing, during staffing, and we have a judge who oversees all of the, I guess, work that's being done, and that's who we kind of all report to. There is a public defender that's assigned to each courtroom. There's a state's attorney, and then individuals bring their own private defense attorneys if they want. But what we do is our judge doesn't wear robes. We all sit at the same level and try to make sure that everybody has that community feel, and, you know, just try to at least make it even look restorative from the time that they walk in.
That's great. I mean, it sounds like a treatment court or a problem-solving court, and I didn't realize that the model was being used as an RJ court. So thank you. Appreciate that. Sarah, so tell us about how you how RJ works in Vermont, or in your county in particular.
Yeah, I'll specifically talk about my county because I do think it's slightly different than some other areas, more rural areas, especially in Vermont. But in Chittenden County, we have all of our sort of justice work is done in the community by nonprofits, specifically community justice centers. Each town or city in the county is represented by one of those community justice centers, and they do all of the restorative work for any criminal activity that is sent to them. The majority of those cases are done entirely in lieu of prosecution and before the cases come to our office, direct referrals from law enforcement, or they come to our office, the paperwork comes to our office from law enforcement and we send it back and tell them to do a direct referral to the Community Justice Center. Occasionally, for some reasons, we will do the direct referral ourselves, but it is all in lieu of, majority of it is in lieu of criminal charges. If those folks do engage and are successful, then we never see the case again. If they don't engage, the Community Justice Center may reach out and ask us to charge it, and we make individual decisions on each case about whether or not it's really worth criminally charging, especially because of the gap in time that sometimes happens. But luckily, we also have that same option at multiple different points throughout the life of a case. So sometimes we'll have cases that are pending. It's clear in conversations with the victim, whether they know what it's called or not, that they want a restorative practice to happen between them and the person who caused them harm. And so sometimes we'll do it while the case is pending. We'll give the person immunity so that they can engage in the process and then send the case sort of indirectly to a community justice center. And if they participate, we might either give them a different outcome or we might dismiss the charge. And then the final option is to do it as part of their resolution. So they might plead guilty to the charge, but we ask that they do a restorative process while they're on probation or as part of their post-conviction. That, from my perspective, is most often used in cases that are pretty violent, like violent cases of violence or serious offenses that we felt a conviction was still necessary. I make it as a part of every offer I'm making when I'm prosecuting a law enforcement officer, because for some particular reason, the conviction might still need to be, we might still need the conviction, but we want that officer to hear from his community about how this harmed them and give them an opportunity to engage in that process. So we have the option at all of those different stages, but the majority of the way that it's used in Chittenden County is pre-charge and in lieu of criminal charges altogether. So we don't see the cases, we don't handle the cases at all.
So that model sounds different from our other four panelists. And I'm curious, is that of your creation, and are there MOUs or anything that support that approach?
Yeah, it's all through MOUs. And when I was I was a prosecutor in this office before I was the elected, and the directive from my predecessor was really to use it on incredibly low level offenses. Frankly, ones that I didn't think we should even be charging were sort of the ones that were being sent to these community justice centers. And the more that I started to learn about restorative justice and meet with these organizations in the community, I realized that we were really missing out on a huge opportunity to limit people coming back into our communities, and also to help the folks that are harmed in the moment. So we came up with MOUs for any offense. So by statute, any offense can go through a restorative justice process. Up until this legislative session, the only ones that couldn't were domestic and sexual violence, but we did, after several years of battling that out in the legislature, we did just overcome that as well. So we can now use it in any offense. Again, at what stage we use that will still be different, but we can use it. And there is statute around it, but it really is individual prosecutors' discretion.
Perfect segue. So you've all described different programs, all of which rely on referrals, either directly from police or from prosecutors within your office. And so I'm curious how you safeguard against implicit or perhaps even explicit bias in the referral process. And Jay, maybe I'll start with you. Any thoughts about that? And you're muted, just FYI.
I am so sorry. I missed part of the question because I was trying to look at the list of questions and.
Oh, yeah, don't do that because I'm going to mix it up.
Yeah, I should have just.
So
I'm sorry.
what I was saying was that each of your different programs relies on referrals.
Right.
And that's an exercise of individual judgment by someone who's making that referral. How do you safeguard, or are there any safeguards in your program to protect against implicit or explicit bias in the referral process?
I think that there isn't one right answer in terms of how to protect against implicit bias, because we all have some sort of bias. But the criteria for screening and eligibility that we have is meant to, I guess, help circumvent some of that risk. Individuals have to live or be part of that community, and demographically and economically, so social demographically speaking, a lot of the individuals in the various neighborhoods and the surrounding neighborhoods of those. So to be more specific, Inglewood, for example. So on the south side of Chicago, it tends to be predominantly African-American, Black. And as we go more west, it becomes more Latino. Our city is just set up in a very separated way. But because of that, it makes it where, in terms of who we're making the offer to, is based less on what they look like, what their status is, and more on if they're in the community that we're attempting to repair the harm that was done to.
Got it. All right. Thank you. Chris, you want to weigh in on that one?
Sure. This is again something that we're working on, and when you're only accepting 10 cases a month, honestly, I don't feel like it is being offered in an equitable fashion right now, because some people are getting a benefit that other people are not getting merely because of capacity. A couple of things that we do is that we look at the demographics of all cases charged in Denver County. So we look at race, we look at age, we look at gender, for all of the crimes in Denver. And then we look at those same statistics for all of the cases that get a restorative justice offer, and we compare them. So if we notice that we are offering restorative justice to more white defendants, if we see that we're offering it to more a younger demographic, then what we do is we kind of backtrack and look at those referrals as they're coming in. We have been pretty equitable, if even offering more to people of color in our RJ referrals. But that being said, there's still absolutely bias, implicit and explicit, that is happening. One thing that we're looking at, future oriented, to try to start getting this offered in a more equitable fashion is to offer a thematic process. So come up with a set list of criteria for everyone charged with a specific charge who has the same criminal history would start with a restorative justice offer. We won't be able to do that across the board. We will be able to do that starting with a charge, just again, because of the size of our county and the capacity of our community partner. But it's a step if we can successfully do this. And so what that would mean is that all of those people every month would have an opportunity to go through a process where they would go on the same day and they would go through the same kind of community process, but the facilitators would all go on this one day. So it would be less sort of having to do the individual scheduling, and would take out from the community partner side some of their resource heaviness that they need. And so we think it would be a way that they could, with the current level of funding, be able to start this. If we could do that, successfully with one charge, then hopefully we can expand that down the line. We also have a restorative justice program that's offered through our diversion program, which is a DA run program. And so another thing we're looking at is, could we partner with more than one agency? Could we find ways to partner with the internal restorative justice program as well, just so we have more opportunities to offer, so that we can be more intentional on the bias piece, again, both explicit and implicit, because honestly, there are some prosecutors who think this is a great way to resolve cases, and there are some who do not.
As you were talking, it made me think about opt in or opt out. And what if the default were going to RJ, and then
Right.
there had to be a conscious decision to move it to the more traditional model?
I love that.
Sarah, did you want to weigh in on that? It looked like you were about to unmute.
The only thing I would just add is that part of how we have tried to address this, and I don't know that we're doing a great job, but was to do the MOUs, because we found that there was definitely disparate outcome. Like the cases that law enforcement were referring were certainly disparate. And we also were, restorative justice, a big part of it is obviously that victims are supportive of the process and are centered in the process. But we also know that white victims of harm by a Black or brown person are less likely to engage or want to engage in those programs. So trying to figure out ways that we made it essentially a policy of our office or these MOUs that these cases were going, and then working with our community justice center partners to talk to those victims about the process and trying to essentially get them on board by understanding what they really were going to get out of it versus what they would get out of the system. And that seemed, as far as I've heard from them, seemed to work really well to start to really engage in conversations with them about why they're not supporting it or why they don't want to engage in it. Because of what we were seeing. We have a little bit more of a class issue in Vermont, feeling like people who might not have access to services in the same way, or even phones or ways that they can get back in touch with these community justice partners, or have significant substance use issues, was a really bigger hurdle for us of trying to figure out how to make sure those folks can also still engage and aren't booted into the criminal legal system because they don't have access to a phone, for example, and or a bus pass or a way to get to the community justice center. So that's actually our bigger issue, is figuring out how to do that.
All right, well, we're going to definitely get to obstacles in a moment. Damaris, let me ask you this. Presumably having an RJ program lowers somewhat the docket in the regular court system. But in addition to that, I'm wondering what advantages do you see to having restorative responses?
Actually, here in Alameda County, unlike some of the other panelists have described, we have a much smaller number of cases that are referred to restorative justice. So it doesn't actually lower our dockets very much, because it has mainly been, the focus is on more serious offenses, and that's the intention, is to refer much more serious offenses and not misdemeanors at all, or even nonviolent offenses, but focusing on offenses where there's person-to-person harm. So it hasn't, and then our community partner can only take a certain number of cases per year, and it's just that one partner. There aren't volunteers, so it's a much smaller number of cases. However, I think that the benefit, the positive benefits of utilizing restorative justice is some of the things that I quoted earlier, including satisfaction for participating survivors, the reduction in recidivism. It's basically one of the things that I do. In addition, I mentioned, or you mentioned in my introduction, that I also responsible for Racial Justice Act coordination, and have worked in racial justice and academics, and do a lot of trainings around there as well. And so one of the things that we know from the research pretty well now is that the traditional criminal legal system hasn't been very effective in achieving our public safety outcomes. The United States has the highest homicide rate through gun and non-gun violence of any sort of Western industrialized country. And we also have the highest incarceration rate. So although we, have you know, we have only 5%, I think, of the rural population, but 25% of the incarceration rate. So we have one of the highest incarceration rates, as well as the highest homicide rate again, developed countries. And so our goal of having public safety and reducing violence by relying on incarceration has just been a failure. So restorative justice is one possible alternative. It's not a be all and end all to cure everything, but it's one alternative to move things in the direction of relying on something other than incarceration to accomplish our public safety objectives.
Really fascinating that in many places, and at least historically in Vermont, where I am, restorative responses was seen as an option for the so-called lower end cases. And Damaris, what you're saying is you're using it at higher end cases of interpersonal violence and perhaps other situations, which I think demonstrates its potential suitability really across the board. I'm reminded of the Daniel Sered's book, Until We Reckon, and she really talks about the most important use of this is at cases that we might say are at the higher end, which then of course raises the political issue of what a legislative body or the voters might be willing to accept, because there still is this notion that this is somehow a softer, more lenient response. But Jay, curious how you see RJ benefiting your communities.
So there's obviously a bunch of benefits to restorative justice in general, but the main ones that I tend to focus on, is the positive interactions with both the community members the opportunity for a positive interaction between community members and offenders of violence, or committers of violence, and then as well as positive interactions with young people who get caught up in this system, if that makes sense. So I do believe that part of one of the biggest results of the systemic racism and systemic disenfranchisement of Black and brown people when it comes to the criminal legal system is that our people don't trust this court system. It's not common to walk into a courtroom and see a prosecutor that looks like you. In some places, it's not even common to walk into a courtroom and see defense attorneys that look like you or judges that look like you. And even when you do, you kind of, the widespread, not everyone, but assumption is that, they're all out to get me, they're working together in cahoots. To me, this creates a great opportunity for individuals when it's their first time interacting with the criminal legal system, seeing that this is other people that are part of your community. These are other people who care about the outcome of what happens to your life. These are people that want to see you do better just because you exist. So I think that that's super important for me specifically as a young Black man. I'm actually 28, so I'm within the age limit kind of some of our participants from the South Side. I think it's extremely important to have the interactions with me, I should say. I don't, coming into the courtroom and seeing someone that looks like you and knowing that, they're not just out to get me. They're not out to lock me up in the system, book me, lock me up, throw me away, and then become, part of that reoccurring cycle. So I do think it's a chance to build the trust between the court system and the community, as well as it's a chance for young people to have that intervention before going into referring back to the infographic that was used earlier. Usually if someone ends up interacting with the criminal justice system at, age of 18 or even as a youth, it is a high indicator that they're going to continue to be in and out of the system. This is a chance for us to act as intercessors to that, stopping it, before the train gets on the tracks, and give them a chance to reset and have an attempt at life the way it should be, I guess. So I think that those are the advantages more so are to the community and the individuals than to even, yes, our recidivism rates drop. Yes, crime goes down, communities feel safer, but even just on a like more personal level, someone walking into a courtroom and feeling like they have a hope is like, you can't really put a price on that.
The most important deterrent there is, in my view, is hope. Definitely not punishment. I'm also thinking, Jay, we've structured the court system as a place where further pain gets inflicted. And I love the notion that it can also be a place where good things happen, and consistent with accountability, but there's almost room for celebration when people really can understand their behavior and actively make changes and make amends. Folks, I know our time is running down a bit, so I'm gonna skip a few questions so that we have time for some Q&A from the audience. I'm going to skip some questions I really wanted to ask, but I'm curious, and Chris, I'll start with you and then maybe go to Damaris on this. What do you see as the philosophical, statutory, or financial barriers to broader use of RJ in your communities or in your office?
Well, some of this I've already kind of touched on, but financial for sure. The way that our program is funded right now is that the DA's office provides a significant amount of money through our budget to run the program, and then we also do a yearly fundraiser, and we have some private funders who donate to the community partner. When I say we, I mean the community partner does, which allows us to run the program at its current capacity. I'd love to expand the program, but without money, that's just not a reality. And from the community partners side of things, we're really at the point where they can't continue with just a purely volunteer model to expand. So they would need to hire someone. And then in terms of looking at hiring, people want to know that it's not just a one-year grant funded position. So they want to have some security in the funding before they would hire. And so that's kind of where we are now is how do we get to where we can get more money, in today's budget for, criminal legal system reform. We're struggling with that. So that's kind of the one barrier. And then I think the second barrier is buy-in, is openness for our program within the office. We do look sort of at broader support, the more that we've tried to start doing some trainings for law enforcement so that when police file a case or submit a case for filing, that they maybe would know about the program and could even right at those very beginning stages, look at this case for restorative justice. Because if a DA sees that, then that will open their mind a little bit more to that. But it kind of ebbs and flows, and especially post-COVID with the amount of turnover that I think a lot of prosecutors' offices have seen across the country. It takes a little while for someone once they become a prosecutor to kind of get their feet underneath them, and then to start thinking, okay, well, here's our current system, but what are some of these alternatives that are actually showing some better results than what we have in front of us now? And so it takes, from my role being in the office and trying to train people and get people on board and really work on that, ever present goal of culture change. It's really difficult right now. It's really difficult with the turnover and the capacity. Kind of those two, they go hand in hand in terms of some of the barriers that we've been seeing. So those are kind of my two main things.
We have not figured out how to, put in quotes, reward prosecutors' offices for avoided court costs, both in terms of cases filed and lower recidivism rates. But that's having an impact on the system, but the prosecutors who are having that positive impact aren't getting rewarded through funding to further support those programs. So that I do think requires some legislative action.
And we've done things like we've even put it in some of the reviews so that when a prosecutor does their yearly review, it's looked at. Are you using alternative programs in the same way that, you know, you're taking these cases to trial? Are you also looking at alternatives? And I think some of those things are important, you know, internal incentives, but again, we're such a small drop in the bucket in terms of the number of cases that are filed in Denver that.
But that's really important because at least historically in Vermont, prosecutors' offices were funded based on the number of charges filed, which just creates this perverse incentive.
Right.
Damaris, what are the obstacles, impediments to further expansion of RJ in California, or at least Alameda?
Yeah, similar funding, definitely likely the biggest obstacle. In fact, our community-based provider is really running out of most of the funding at the end of this fiscal year, which is in a couple of days, and then will be very limited in the types of cases and the geographic area of cases that we can refer to them. And so this getting funding for the programming is a huge challenge. And you mentioned Danielle Surratt, and I think that in the research that I've done about programs across the country, I think the common justice model that she uses in New York, I believe it is one of the most effective programs that I've seen, at least with, I want to say 7% recidivism rate, which I know recidivism isn't the only measure for how successful a program is. But in terms of getting buy-in, which is one of the other obstacles, it's one of the things that more traditional law enforcement systems players recognize and can respond to. And so in that model, they're able to use wraparound services, not only for the persons who caused harms, but also for survivors. And that takes resources to be able to provide wraparound services for both parties, as well as those directly impacted, takes a huge amount of resources. And they've been able to somehow get the resources for the most part. I mean, I'm sure everyone needs more assistance, but to be able to use that kind of system. And so we're not really close to that right now, and still working on how can we get the most amount of services that we can for not just the persons who caused harm, to look at root causes and what things, resources, and other services they need to address those root causes, but also for the survivors and the persons who were harmed, so that there's not a sort of disincentive to participate in restorative justice, especially since we're doing it at the pre-charge level for the most part, where they're not involved in courtrooms. So how do we get all of these services to survivors, even when no charges are filed and there's no case pending in court, and including wraparound services? And so the other thing, like I mentioned, is buy-in, and how do we start to, it seems like in our culture, in our society, there's so much commitment to this ideal that punishment equals safety and punishment equals healing. You know, actually talking to survivors and talking to, lots of, folks who are just, believe that as long as this person is punished, I'm going to feel better. Or as long as a person is punished, that means justice is done. So just to start to find other ways to look at whether or not to start to break through that fidelity to punishment being the cure to all of the public safety concerns. And there's just a lot more research now showing that even when punishment is utilized, it's still not the only answer. So being able to address root causes, being able to address some of the socioeconomic factors that drive crime, because everyone who commits crime isn't punished. There's a ton of people who, engage in crime and they never get arrested. So as long as we're relying on this punishment model of that, fraction of the people who are actually arrested and prosecuted, there's still all of these social determinants that are driving crime to happen. So restorative justice is one way that we can start to address these social determinants for some individuals. And it also would have a ripple effect to create more circumstances where crime is not as much of a factor than just those people who are involved in the system. As I think Jay talked about earlier, it has an impact on the entire community to start looking at things differently when we're using these models and letting folks know that we have to start looking at things, widen our lens from the narrow view that we've historically been utilizing.
I have a gloomy comment and then a request for everyone who's listening. The gloomy comment is, painful as it is, we seem to be entering another presidential election cycle, which we know people are going to run on this law and order punishment. And I think prosecutors in particular have the ability to raise their voices to say that's not the only model. And we need to start thinking about effective responses to harm, not just punitive responses that often compound the harm. Am I optimistic that's going to happen? No, but my request to everybody is, this is going to sound very unusual, but we get interviewed a lot by the press. And the press uses remarkably dehumanizing language in reporting on our work. Convicts, criminals, ex-cons. And I made a personal promise that if I read anything or heard any reporting by a Vermont reporter that I thought used dehumanizing language, I would email or text that reporter. And I will tell you, some of them have started changing. And I think language informs attitude. And if we can get the press to start understanding that we're talking about human beings and report that way, that maybe that starts to change the population a bit and how they think about people who have caused harm and the importance of giving them the opportunity to make amends. And Sarah just went off screen for what may end up being the final question. And that is, looping back to something I said in the beginning, to what extent, if at all, do you think RJ has a role for how you as the elected state's attorney interact with people within your office, separate and apart from harm in the community?
I think, once you do, your research on what the restorative, not just like talking about peace circles, but really what the root restorative practices mean and their origins. I think if everybody practiced that in life, we'd have a much different world in front of us. If everybody acknowledged the harm that they commit in their own communities or their own lives and really worked to restore that harm, we would just be so different. But unfortunately, our legal system especially sets people up to do the opposite. As soon as you've done something wrong, we tell you not to say anything, don't talk to the police, don't talk to the victim, you can't talk to the victim. We separate these. And I think the more that we get the government out of people's conflict, the further we can go. And I think that the same can be said for any relationship you have. And so I do try to practice that in my office. You're constantly sort of trying to balance how you interact with your staff, making sure that you are in a very professional place and they understand what is required of them, but also constantly reminding them that although we are trying to do things differently, we are still in a harmful profession. And the way that I do that is by just talking about people like people. You know, one of the very first policies I had was to not use the term defendant in filings or in court and to use people's names. That in itself was really hard for a lot of prosecutors, and it wasn't, it's just, you know, we learned that in law school. You don't learn that when you become a prosecutor. We learn that on TV and in all these other ways. That having those conversations and acknowledging our part in where we're at now, I think goes a really long way for people. I have, you know, a quote down the big corridor in my office that says, people are like puzzles. They take time and patience to understand. And then we always had, before COVID, we'd have a puzzle available in the office. People could go in and work on it for 5 or 10 minutes. And then we hung all those puzzles on the wall. We have a print in our office of Khalif Browder. His parents or his family had wanted me to have a copy of it after we stopped requesting cash bail. So it's in our lobby with a letter, you know, explaining why that print is in our office. And so, you know, if you are confronted with the reality of our system while also being confronted with this message of patience and mercy and compassion, people see that. They see it every day when they're coming to work. They see it in your own practice. I have a caseload, so I'm able to also practice this with my own cases. And so I'm not just telling them to go do it on their cases and then take the brunt from law enforcement and judges or whoever, but I'm in it with them. And so I think that for me, in my ability as a smaller county, of course, it seems to go a long way with staff, that you start to live it and then want it for yourself and for your work.
I want to thank all of you for really helping to redefine what it means to be a prosecutor. And I think as more prosecutors come to appreciate this different role and different approach, that's going to help influence hearts and minds throughout the country. So thumbs up, thumbs down. If anyone in our audience wants to learn more about the program you're involved in, is it all right if they reach out to you? Okay, that's pretty good. Avery, how are we doing?
Doing good. Thank you all again. And Bobby, special thanks to you for really facilitating this conversation today. We're going to take it to Q&A, and folks, feel free to submit your questions if you have any. But we'll start with one of the first ones we've received. Looks like this is out of Pima County's attorney's office, which I want to say I quickly Googled, and it looks like Arizona. Yeah, aside from the specific case eligibility, the need for a responsible party to accept responsibility for the harm, and then for survivor buy-in, what other types of screening criteria have you found helpful to ensure the referred case is appropriate for restorative justice? I think, Jay, you mentioned some assessments, but are there any other specific risk assessment tools, mental health or substance use out there that you would recommend to better screen eligible participants? And Jay, if you can refresh us and mention what that one screening tool that Cook County is using, that would probably be helpful as well. And if anyone else has any recommendations.
Yes, so to be clear, the risk assessment that I was describing, that's for someone once they're already part of the program, but that is, that's how we use it. It is the Ohio Risk Assessment, and it is implemented for young and emerging adults to discuss like the level of risk they have and the likelihood that they might reoffend or things like that. But in terms of screening, just to try to answer the question specifically, one of the big areas of the screening criteria that we focus on is not just the fact that they live in the community, but like how they interact with that community. For example, some of our areas are very heavily like gang influence, gang violence. Trying to understand what role they might play in that gang. We do have like certain units that follow like drivers of violence in certain areas. So, you know, cross-referencing every screening with that case, I mean, that list to make sure whether they are good or not, I guess, specific for it. And then, yeah, and then we do also, once they're part of the program, again, is we will have individuals, if they're charged with drug cases or gun cases or things like that, we do try to refer them to things or recommend things that addresses that. So mental health assessments, drug evaluations, drug use assessments, and then even just anger management classes, parenting classes, things like that. So we do use different things to try to address it and figure out what they need. But that's once we already have them in the program.
Thank you. Okay. And when I said submit Q&A, y'all really came with them. So I'm gonna go through a rapid fire if I can. All right, so let's see. It sounds, how are each, and you could probably all answer this, how are each of the RJ programs funded? And I know some of you mentioned it, but just to clarify, how are each of some of these orgs and just programs funded?
Okay. I'll just say for our program, the community-based organization has it obtains funding through nonprofit, its own funding essentially through nonprofit sources, whether those are grants from different justice organizations or foundations, they have their own funding.
Yeah, in our jurisdiction, because it is through the leadership at our office, they did make sure that it was its own court as part of the Cook County court system. A lot of our funding comes from the Cook County's budget, but the services that we provide through the courts usually comes from the budget of those community-based organizations. So that's a lot of grant funding and resources like that.
Ours are funded through state funding. The Department of Corrections actually funds our community justice centers, which I despise in how it looks and how it sounds, but it's, I think in theory was done because they are filtering a lot of cases out that would have otherwise come through the system. So good in theory, but I would like for them to have their own funding, not associated with corrections.
And the DA's office provides about 75% of the funding for our program, and then the community-based organization does fundraising and has some private funders for the remainder.
Okay, thank you. There are a couple of discussions on this Q&A, but we can jump into one of them. It looks like, Sarah, you talked about this, about folks contributing and kind of practicing and implementing RJ in their day-to-day. So I appreciate your examples of how you're modeling that practice with your staff. Someone said, do you see RJ becoming the norm in our lifetime? What would it take to realize that vision? And I'll start when we stop caring about the money. That's my answer. But you all are the experts. So pretty much when we stop caring about
the power and the money.
I think also just like the idea that conviction equals public safety, like that belief within the office is so prevalent. And I think until we change that, until we stop, like a conviction has nothing to do with public safety. It's not keep anyone safe. If anything, it keeps you less safe. But until we change that, I don't think we're going to see that in our lifetime. I wish.
And where I live specifically, I'll say, it'll take people to like close their ears and just look at the numbers and the data and stop listening to the fear mongering that happens with the media. They will scare you into thinking that every single person here is trying to kill each other. Like, I don't know, listening to the news about Chicago is terrifying when I live here. And I'm like, no, these are just people that need help. So like, stop listening to stop giving those voices platforms, because we know that crime and punishment, it doesn't work. It hasn't worked. Like, I don't know. Yeah. It'll take that.
As someone at the other end of my career, I can tell you I've never spoken to a retired prosecutor who has said, I sure wish I had been more punitive while I was working. I don't think that person exists. And I will tell you, if I could do things over again, there's so many things I do differently. And so for those of you who still have an opportunity to do some things differently, I hope you'll seize that opportunity. And that sometimes means sticking your neck out a little bit, but that's what leadership is about. And that's a positive way to use the power and discretion the prosecutors have.
Yeah, and I would just add, I think Sarah talked about this earlier and about integrating it into our offices, that restorative justice is not just, diversion program, but it's principles. It's essentially like, how do you resolve any conflict that comes up? How much do we value relationships with each other? And when we start to live in a culture where we start to value relationships with each other, we see all of our humanity in each person, and we value that. As we move more towards that type of a paradigm where we value our connection to each other and our relationships with each other, then we'll start to see, kind of hope maybe we'll go full circle back to indigenous ways of resolving conflict, where people weren't disposable. It was a community, and the community there were times when people were told, okay, you're not in the community anymore, but that was not the norm. The norm was that everyone was part of the community, and when there was conflict, there was a way to resolve it so that you still maintain the community and the relationships. And we've gotten so far away from that to having people be disposable now. So hopefully that as we can get back to that model of seeing that we're in a sort of microcosm, we're on this planet, but it's one planet where we're all somewhat connected to each other. If we can start to see and honor those connections among each other, and value that, and see that then I think we can start to get back to a paradigm where we're not seeing people as disposable. Not saying that they shouldn't be accountable for harm that is created, but accountable in a way that doesn't just, get rid of people because they've made a mistake, committed harm, or done something like that. And I think at the same time, when you have that, there's less likelihood that harm will happen in the first place.
Thank you. All right,
That's recorded, right,
yes, it is.
Avery? Because that was brilliant, moving and brilliant.
Absolutely. We have a technical question. It's about a new diversion program out in Virginia. There's an MOU with both a county and a city. I love this scenario. And are doing about 1 to 2 adult cases per month, pre-plea with default for dismissal. Now they're receiving some more serious cases where the prosecutor and/or harmed person wants to leave a conviction on the table. My org is worried that this will become a precedent over full dismissal. Are there any of your programs doing RJ with a downgraded charge for conviction? And this person would like to hear about it. What do you
We
all?
are not, but we are not, but we had I have a very similar type of program. So we dismiss, and I've had prosecutors who have wanted to do that exact thing where let's do an unsupervised probation with restorative justice being the only condition, and we get the conviction. And that's kind of where I was just chatting about a minute ago, is just the idea that like we need to have these convictions, and that philosophy being sort of ingrained, I would say, in the prosecutor's office that I'm working in. I won't go beyond that, but I stood pretty firm and just said, we're not going to do that because of the fear that it would become the way of doing things. And while that might mean that then that specific case doesn't get referred, I think it safeguards the idea that restorative justice kind of becomes a term of probation, essentially, which is was my fear of what would happen if it ends up being kind of like, well, we'll just add on restorative justice, and it can be used in the system in different ways. So absolutely, I'm not saying that that's not an option, but I get concerned, I would say, when people want to do, we need to have a conviction and then we'll have restorative justice. And then what comes next? Are we going to then also have monitored sobriety? And we'll also have, like you can just see kind of the slippery slope of where that goes. So I'll say I hear your struggle and have faced it pretty regularly in our program, and happy to chat about that offline with whoever's question that was, if you'd like to.
One of the things that points out, what a fascinating structure we have in this country, because there's so many different models and so many different expungement laws and sealing laws. Avery, may I put a plug in for the map?
Absolutely.
So one of the projects of the National Center on Restorative Justice has been working with the National Association of Community and Restorative Justice, NACRJ. And if you go to nacrj.org, you'll find a map. And the goal is to have pinpoints of all the RJ programs in the country. So to our panelists and to our audience, check that out. And you may learn about some programs that you didn't know about in your area, but also if you're not included there, you'll find information about how to get your program added to the map. And someday the pins are red. Someday, hopefully, the whole thing will be red. Well, you need to be careful about that.
Thank you, Bobby. I just threw it in the chat. Nope, you're all good, panelists. I just threw it in the chat to visit that website, but I'll put myself on mute to whoever was just speaking.
Sorry. So I keep rereading this question, and I would like to try to tackle it because we are one of the courts that still have, it's like part of it's still part of the criminal justice system. Where in a technical sense, in our office, the possibility of conviction never leaves the table until it's dismissed, because the charges are pending and they can always be sent back to the criminal court. For me personally, and also side note plug, shout out to Kim Fox, my boss, because her restorative practice and approach to everything is what enables us to be able to do this. So back to the topic. I sometimes use the fact that there's a possibility of conviction still remaining as a way to convince some of my less restorative counterparts to actually let me take the case. Saying, hey, yeah, if they fail the program, there is still the possibility that they, if you're right and I'm wrong, you don't want to take a chance on them. If you're right, they will come back to you and then you can prosecute the case as you please. So in that sense, I think that the conviction doesn't necessarily have to be a bad thing when it's used, with it being on the table, I should say. It doesn't have to be a bad thing if it's being used as negotiating power. And sometimes even that is good in terms of talking to victims of crimes when they want to know, if they're skeptical about the system and whether it's going to actually work, being able to say, well, we can try it because this person is redeemable, it's worth trying. And if it doesn't work, then you can still go the traditional route. So I think by leaving it on the table, in some instances, it allows for a chance to repair harm within that person in the community that otherwise wouldn't exist. Even with reduced charges, that individual may not have a felony, they might have a misdemeanor, but the areas of their life in which need to be restored still exist. So I don't know. Well, I guess what I'm trying to say is that if you use it the right way, it's not necessarily a bad thing if it helps us get a foot in the door. Because we have to remember that we are still operating in the current system as much as we want to change it. So that's all.
I like that point, Jay, and you say, if I'm wrong, the case goes back to you. And then the second part of that is, but if I'm right, you need to start looking and leaning into this work. So I'll do that after every case. All right, we're winding down. There's a lot of questions specifically about like law enforcement buy-in, probation officers. Probation particularly keeps coming up in this Q&A submission. So I'm curious, I think we're gonna have to do something with probation and webinars because that is a topic that we have not really touched on. So thank you folks who have submitted those. Because folks were saying like, what's the role of them in this? So I don't know if anyone can speak to that particularly, but what's the relationship with law enforcement? How do you get buy-in from a law enforcement perspective, probation? How do you get all of your colleagues and folks, system actors to get on board? Or what's the relationship like currently?
Asking that question with 3 minutes remaining is tough. I will say, as somebody, I have a lot of, unfortunately, experience with this. Our law enforcement is very much not on board. Part of the reason that we did MOUs was just essentially force them to be, to make them do direct referrals and then send them, if they send them to us and we send them back, then they have to do it anyway. And so it's more work for them if they send it to us. But you know, I just had a contested campaign, and this was a huge part of it, was just law enforcement on the streets who are talking to more victims than I am when a crime has just occurred, and immediately telling them nothing's going to happen. It'll be a slap on the wrist, and downplaying restorative justice before they even have an opportunity to talk to our office or an advocate, if they even send us the case at all. So that has been, and then the media just played into all of that. That has been a huge obstacle for us. I will say that just a couple of days ago, I got this long email from one of our biggest cities talking about how they have a 90% success rate in their community justice center and significantly smaller recidivism rates than they've seen in the past, and how that has, their leadership buying into that has now started to get their officers to buy into that. As they're showing them those numbers. So I would start by just saying leadership down is a huge issue. If you can get the higher ups to understand it and appreciate it, they will train in that mindset. But until then, it is a huge issue. And I think the biggest issue is that they are the ones talking to the person harmed immediately after that harm happens. And so they are starting the conversation in a negative way, which I have said repeatedly actually creates more harm for victims. So it is I don't have a good answer to it because I'm in the thick of it right now, but I do think that taking some of that discretion away by MOUs or making sure that certain cases always go is a good start.
One minute left. Thank you all again for just really taking the time to just really share your work and share with us wisdom and just the ongoing work that still needs to be done. For more information, please make sure to visit our website. A copy of the recording should be made available if you're registered for this webinar. Maybe in 2 or 3 days, you'll receive a link. Please encourage you to fill out the feedback. We want to hear, like I said, probation is going to be put up on the board for bringing more content topics to this discussion. So thank you all so much. I will now stop the recording, and please enjoy your weekend and the rest of your summer if that's possible.